Everybody, welcome back to Patriot's History. I'm Larry Schweikart, the co-author of Patriot's History with Michael Allen, now in its 40th printing, 5th edition. As I promised, I will have an updated edition for you later this summer. I'm almost done. I keep saying that. New stuff keeps coming up, but I will get it out. It will be available free on the wildworldofhistory.com website in PDF form, along with any changes and revisions that we made up to that point, including new research. It'll have to be as in, on this page, insert this here. Sorry, if they won't do a new edition, that's the best I can do. Let me remind you also, we are making this into a feature film followed by episodes. So folks, help me out. The initial fundraising phase is buy Larry a coffee. And I need your help in order to fund the 20-minute pilot that we need to do to get to the next stage. I won't bore you with all the steps that we're going to have to go through to make this, but it's a sound plan. We can do it, but I need your help. So buy me a coffee. All right. We have been reading from the U.S. Constitution in Chapter 4, Nation of Law. And last time we read through the original Bill of Rights. There were 12, of which only 10 were ratified. So we're moving on now with the additional amendments since the first 10. The 11th Amendment proposed 1794 and ratified 1798. The judicial power of the United States shall not be construed to extend to any suit in law or equity commenced or prosecuted against one of the United States by citizens of another state or by citizens or subjects of any foreign state. So the Supreme Court is limited into jumping into these kinds of cases. 12th Amendment proposed 1803, ratified 1804. This was due to the elector problem. And if you remember, originally, you would cast two votes, one for a president and one for a vice president, and they were independent. And that meant that, in theory, which is exactly what happened in 1800, actually in 1796, although the parties weren't well formed then, but at any rate, in 1800, we had a president who was a Democratic Republican, a Jeffersonian. That's what they kind of called their party. Again, parties didn't exist the way we know them now, and you had a vice president, Aaron Burr, who was a Federalist. Now, he'd gone back and forth, but you see the problem. That as they saw it now, you could theoretically elect a president of one party and a vice president of a party totally hostile to that guy and become a stick in the mud and become an impediment to getting things done. So that's the origins of this amendment. The 12th Amendment proposed 1803, ratified 1804. The electors shall meet in their respective states and vote by ballot for president and vice president, one of whom at least shall not be an inhabitant of the same state with themselves. They shall name in their ballots the person voted for as president, and in distinct ballots the person voted for as vice president, and they shall make distinct lists of all persons voted for as president and all persons voted for as vice president, and the number of votes for each, which lists they shall sign and certify and transmit sealed to the seat of government of the United States, directed to the President of the Senate. President of the Senate shall, in the presence of the Senate House of Representatives, open all certificates, and the vote shall then be counted. The person having the greatest number of votes for president shall be the president, and if such number be a majority of the whole number of electors appointed, and if no person has such a majority, then from the person having the highest numbers, not exceeding 3 on the list of those voted for as president, the House of Representatives shall choose immediately by ballot the president. But in choosing the president, the vote shall be taken by states, the representation from each state having 1 vote. This is the same as before. A quorum for this purpose shall consist of a member or members from 2/3 of the states, and a majority of all the states shall be necessary to a choice. And if the House of Representatives shall not choose a president, whenever the right of choice shall devolve upon them before the 4th day of March, the next following, then the vice president shall act as president as in the case of the death or other constitutional disability of the president. So in other words, if the House can't make a decision after that, the sitting vice president becomes president. The person having the greatest number of votes as vice president shall be the vice president. If the number be a majority, the whole number of electors appointed, and if no person have a majority, then from the two highest numbers on the list, the Senate shall choose the vice president. A quorum for the purpose shall consist of 2/3 of the whole number of senators, and a majority of the whole number shall be necessary to the choice, but no person constitutionally ineligible to the office of president shall be eligible to that of vice president of the United States. Okay, now, a lot of wordage. What does that mean? When they did you can't be a resident of the same state. Originally, the thinking was by the founders that a state would vote for a favorite son, a politician from that state, as one vote for president, and cast their other vote for president for the person they really wanted to be president. But as I said, this led to a problem because you ended up with presidents of one faction and vice presidents of another faction. So they're trying to handle this with these distinct lists of who's going to be president and who's going to be vice president. So that's the big change they made there. 13th Amendment proposed 1865, ratified 1865. By the way, note, they went from 1804 to 1865 without another amendment. Neither slavery nor involuntary servitude, except as a punishment for crime whereof the party shall have been duly convicted, shall exist within the United States or any place subject to their jurisdiction. Section 2, Congress shall have the power to enforce this article by appropriate legislation, which it didn't need to put in. Congress always has the power to enforce, to write up legislation to enforce a law. But this basically outlaws slavery. There is no more slavery in the United States of America after the 13th Amendment. And you might say, well, what about the Emancipation Proclamation? That didn't free all slaves. As we're going to see it that when we get there, the Emancipation Proclamation freed only those slaves who were in, quote, those states now in rebellion. Meaning, if you were a slave in South Carolina or Mississippi, Texas, you weren't getting free. Because although the proclamation said you were free, guess what? The Union Army hadn't invaded them. They were still in rebellion. And no state still in rebellion as of 1863 was going to free their slaves. So note that the Emancipation Proclamation did not free slaves in states not still in rebellion. Why? Lincoln needed them. Not the slaves. He needed those states. He needed Missouri. He needed Kentucky. He needed West Virginia, which was now a free state. He needed Maryland. And if he had freed the slaves in all those states, they might have changed sides or made things a lot more difficult. So it has been said, again, we'll cover this when we get to this point, that the Emancipation Proclamation didn't free a single slave. That's simply not true. It freed a lot of slaves in areas of states still in rebellion, such as Tennessee, okay, or parts of South Carolina, the Sea Islands, which were in federal control, or Louisiana, which is under federal control, Arkansas under federal control. But it did not free the majority of slaves in those states which were still in rebellion. Okay. So we needed an amendment to do that. And this is the amendment. Really big one. 14th Amendment proposed 1866, ratified 1868. There are arguments that this was not ratified. Section 1, all persons born or naturalized in the United States are subject to the jurisdiction thereof, are citizens of the United States and of the state wherein they reside. No state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States, nor shall any state deprive any person of life, liberty, or property without due process of laws, nor deny to any person within its jurisdiction equal protection of laws. So this is meant to further enforce the 13th Amendment, saying slaves are now not only free, they are now citizens. Okay. And you'll notice that it says all persons born or naturalized in the U.S. are citizens of the United States and of the state where they reside. This was a big change. Prior to the Civil War, if someone said, well, you know, what's your name, so-and-so? Well, who are you? Where are you from? Say you're in Europe traveling. Where are you from? You wouldn't say the United States of America. You would say, I'm from Virginia. I'm from Ohio. The identification prior to 1860 was first with your state, second with the United States. And this flips that. I know a lot of people hate that, but it's there. It flipped that to be you are a citizen first of the United States of America and second of your state. So it pushed state sovereignty below that of federal sovereignty in the context of civil rights. Section 2, representatives shall be apportioned among several states according to their respective numbers, counting the whole number of persons in each state, excluding Indians not taxed. But when the right to vote in any election for the choice of electors for president and vice president of the United States, representatives in Congress, the executive and judicial officers of the state, or the members of the legislature thereof, is denied to any male inhabitant of such state being 21 years of age and citizens of the United States are in any way abridged, except for participating in rebellion or other crime, the basis of representation therein shall be reduced in the proportion which the number of the male citizens shall bear in the whole number of male citizens 21 years of age in such state. Let me come back to that in a second. No person shall be a senator or representative in Congress or elector, president, vice president, or hold any office, civil or military, under the United States or under any state, who having been previously taken an oath as a member of Congress or as a member of the United States or as a member of any state legislature or an executive judicial officer of any state to support the Constitution of the United States shall have engaged in insurrection or rebellion against the same or given aid or comfort to the enemies thereof, but Congress by a vote of 2/3 of each house may remove such a disability. This was aimed at the former Confederate officials, okay, like the president of the Confederacy, the vice president, Alexander Stephens, Jefferson Davis, the president, the Secretary of War, the Secretary of the Treasury, and state governors who had led these rebellions. It is now, they are now going to try to use this against President Trump, saying, well, he was behind an insurrection. No, he was not. He, on multiple times, said for people to disperse, to protest peacefully, and to go home. I mean, but I'm not saying they won't get him on this. They can get him on anything because they are the Department of Injustice. They have no concern whatsoever with justice. But he would probably win fairly quickly on an appeal because this is just garbage. It's just insane. There was no insurrection on January 6th. It was Patriot Day. It was the day that patriots came out of the woodwork to protest the theft of an election and election fraud in America, which still to this day has yet to be addressed. They are patriots. They should be supported. The jail sentences given to these poor people is just outrageous. It's ridiculous. And someone needs to answer for this once Trump is reelected. People need to go to jail. And it's not the J6 defendants. It's the people in the Department of Injustice right now. Anyway, that's my take. Section 4, validity of the public debt of the United States authorized by law, including debts incurred for payment of pensions and bounties or services in suppressing insurrection or rebellion, shall not be questioned. In other words, we paid out money to suppress this insurrection. Dang it. You're not going to question that. You got to pay us back. But neither the United States or any state shall assume or pay any debt or obligation incurred in the aid of insurrection or rebellion against the United States, or any claim for the loss of emancipation of any slave, but all such debts, obligations, and claims shall be held legal and void. Okay, so illegal and void. So what this is saying is that once and for all, the concept of compensated emancipation is gone. The idea that the slaveholders were going to get any money back for their investment in slaves was gone. On the one hand, you'd say, well, they deserved it. They participated in a rebellion. On the other hand, some of them didn't. And they bought slaves when slaves were legal. So Lincoln opposed this. He wanted 40 acres and a mule, and he had long sought compensation for the slave owners, but he kind of gave up on that by the time of the Emancipation Proclamation, because he just figured it wasn't going to happen. But now, having won the war, the Union is going to stick it in to the southern states, and for better or for worse, they didn't get compensation for slaves. Section 5, the Congress shall have the power to enforce by appropriate legislation the provision of this article. I think that goes without saying. 15th Amendment, proposed 1869, ratified 1870, Section 1, the right of citizens of the United States to vote shall not be denied or abridged by the United States or by any state on account of race, color, or previous condition of servitude. In other words, you're not going to keep Black people from voting. Forget about it. Section 2, Congress shall have power to enforce this article by appropriate legislation. 16th Amendment, proposed 1909, ratified 1913. Get it? I know you guys hate Woodrow Wilson. He's not my favorite. He's in my bottom 10. He was not responsible for the income tax. It was proposed and being ratified before Wilson even came into office. He just happened to get there when the last ratification vote took place. 16th Amendment, Congress shall have the power to lay and collect direct taxes on incomes from whatever source derived without apportionment among several states without regard to any census or enumeration. So you needed an amendment because income taxes were ruled by courts to be unconstitutional, direct taxes, which were prohibited in the Constitution originally. And so it was thought the only way to get around this was an amendment. So folks, I know we don't like income taxes. I know we don't like the IRS, but 2/3 of Americans, either through their legislatures or whatever, proposed this, and 3/4 of the states ratified it. It was not unpopular. And as we'll see when we get there, there's a lot of reasons for this. First, income tax placed almost no burden on 90% of Americans. They weren't going to pay anything. On those who did pay, it was a very, very little burden, a small burden of 1% to 6%. You know, many of us are paying 18, 20%. If you're in an upper tier category, might be paying 25.7%. I don't know. I'm not in that category. But 6%, most people would pay 1% if they paid anything at all. That's nothing. People don't even notice that. So that's one reason why people support it. Second, it's very, very simple. Basically, your income tax form was 1 page, and it wasn't Joe Biden's 1 page, which is how much did you make last year, send it all in. It was a very short thing. How much money did you make multiplied by one of these 6 categories? And that was all you sent in. It was easy to do. You didn't have to spend thousands of extra dollars on accountants to then turn around and pay the government. And lastly, very important, Congress was fully behind this because Congress had been in the process of passing tariffs to fund the country. And the tariff schedules, as they are called, the list of all the stuff that were going to be taxed, had to be fought out line by line, item by item. They would have knockdown, drag out fights over cheese, rope, cotton, milk, hemp, iron, copper, whatever is made was going to be fought over in terms of producers, and those states that made that stuff wanted lower tariffs, and all the other states wanted higher tariffs, but they wanted lower tariffs on their own things. So it was not just that everything had to be gone through a schedule. This was taking an enormous amount of time for Congress to go through all of these schedules. It was really consuming the majority of Congress's time. They needed to be doing something else. And so they were all for it. So like it or not, 16th Amendment's an amendment that was very popular when passed, very popular with the lawmakers when passed, very popular with the people when passed, because as I said, it didn't affect most. Okay, 17th Amendment proposed 1912, ratified 1913. Senate of the United States shall be composed of 2 senators for each state, elected by the people thereof for 6 years, and each senator shall have 1 vote. The electors in each state shall have the qualifications requisite for the electors of the most numerous branch of the state legislature. When vacancies happen in the representation of any state in the Senate, the executive authority of such state shall issue writs of election to fill such vacancies, provided that the legislature of any state may empower the executive thereof to make temporary appointments till the people fill the vacancies by election as a legislature may direct. The amendment shall not be construed as to affect the election or term of any senator chosen before it becomes a valid part of the Constitution. In other words, we move to direct election of senators as opposed to having the state legislature elect your senators. Now, I know many conservatives don't like this at all, and they want to go back to having the state legislatures elect senators. I have a very good friend over on my favorite site, freerepublic.com, named Field Marshal DJ. I know his real name, I won't tell you. Field Marshal DJ. And he has made some very compelling arguments. The guy's a history whiz. And he's made some very compelling arguments going back in history that really we're no worse off whatsoever with the public electing senators and having the state legislatures elect senators. One big problem was that state legislatures got so tied up, they would not elect senators for very, very long periods of time. Some case, almost a year, you'd go without a senator, which isn't right to the constituents thereof. And Field Marshal DJ makes the point that if you look at who your state legislature is now and who they would select and who the people would select, he makes a pretty good case that, in fact, the people might be a little more conservative than the state legislatures. I don't think that's true maybe in South Carolina, maybe not true in someplace like West Virginia, but in Ohio, they were iffy when I was there. In Arizona, how shall I say this? We have a majority control of Republicans in both houses. However, there's 1 or 2 rhinos who would tie up the vote or flip the vote. And you could not get a conservative senator, I don't think, selected by the state legislature. But Field Marshal DJ did this in a lot of states and gave a lot of examples where, contrary to popular perception, this probably isn't as bad an amendment as you think it is. Anyway, I'm just passing on what he's written before. 18th Amendment proposed 1917, ratified 1919, repealed 1933, Section 1. After 1 year from the ratification of this article, manufacture, sale, or transportation of intoxicating liquors within the importation thereof into or the exportation thereof from the United States shall, and all territories subject to the jurisdiction thereof for beverage purposes is hereby prohibited. No more booze. You can't make, sell, or transport it. Now note, you could consume it if you had it, but you couldn't make, transport, or sell it. Section 2, Congress, several states shall have concurrent power to enforce this article by appropriate legislation, which later became the Volstead Act. Section 3, this article shall be inoperative unless it shall have been ratified as an amendment to the Constitution by the legislature of several states as provided by the Constitution within 7 years from the date of the submission hereof to the states of Congress. Now, why did they put that in? For the first, because it's obvious. Well, yeah, those states have to ratify it. We know what they did. They said within 7 years. in essence, you're going to see this with the Equal Rights Amendment. They're saying if you can't do it within a limited time frame, you don't get forever to try and do these amendments. You've got to do it within a time frame. Now, I want to go back to what I just said. I know you guys are going to hate me after this video. What I just said about income tax was very popular when passed. Senators, probably wasn't the disaster we think it was. And lastly, prohibition was very popular when passed, supported by 2/3 of the people, ratified by 3/4 of the states. That's not just a bunch of crazy Baptist preachers out there. That's everybody. And there's a great book on this called Deliver Us from Evil by a guy named Clark. I urge you to read this. He does the research on who supported the amendment at the time. And it was a wide, broad swath of everybody, including urban elites, populist Midwesterners. And what changed was really the urban elites and the news media disliked it. And they forced the repeal. Deliver Us from Evil by Clark. 19th Amendment, the right of citizens of the United States to vote shall not be denied or abridged by the United States or any state on account of sex. Congress shall have the power to enforce this article by appropriate legislation. In other words, women get the right to vote, 19th Amendment. 20th Amendment, proposed 1932, ratified 1933. Section 1, terms the president, vice president shall end at noon on the 20th day of January. Terms of senators or representatives at noon on the 3rd day of January. Of the years in which such terms would have ended, this article had not been ratified, the terms of their successors shall then begin. So there's a gap between when the new senators take their seats and when the new president and vice president take their seats. Congress shall assemble, section 2, Congress shall assemble at least once every year, and such meetings shall begin at noon on the 3rd day of January, unless they shall by law appoint a different day. And we're going to stop at the 21st Amendment. Section 3, if at the time fixed for the beginning of the term of the president shall either have died, the vice president-elect shall become president. If a president shall not have been chosen before the time fixed for the beginning of his term, or if the president-elect shall have failed to qualify, then the vice president-elect shall act as president until a president shall have been qualified, and the Congress may by law provide for the case wherein neither a president-elect nor a vice president-elect shall have qualified, declaring who shall then act as president, or the manner in which one who is to act shall be selected, and such person shall act accordingly until a president or vice president shall have been qualified. So if something happens to a president, the vice president isn't qualified for some reason, or who knows, that Congress can therefore say, we're going to qualify somebody to serve as president until we can fix this. Section 4, Congress may by law provide for the case of the death of any person from whom the House of Representatives may choose a president, whenever the right of choice shall have devolved upon them, and for the case of the death of any person from whom the Senate shall choose a vice president, whenever the right of choice shall have devolved upon them. So if somebody dies in office, Congress may provide a law for replacing them. Section 5, sections 1 and 2 shall take effect on the 15th day of October following the ratification of this article, and section 6, this article shall be inoperative unless it shall have been ratified as an amendment to the Constitution by legislatures of 3/4 of the several states within 7 years from the date of its submission. So again, there's that 7 years. They wanted to make sure that they weren't giving people forever, that 100 years from now, somebody pull out one more state ratifying some obscure amendment that people weren't attuned to, then all of a sudden you got some law that you wasn't even on the books, and not a law, an amendment, right? So they're saying these amendments are serious, and if they're going to be done, they need to be done within a reasonable amount of time. Okay, I'm going to stop here. We'll pick up next time with 21st Amendment. And in the meantime, remember, help me make Patriots history by buying me a coffee. And remember to support Wild World of History with the VIP subscription. Folks, there is a ton of material on the VIP site. You could just teach the lessons in the VIP to your kids without the curriculum, and you probably get a pretty darn good U.S. history lesson. That's without the curriculum. The curriculum is awesome. If you haven't looked at it, look at it online. So think about being a VIP member. It's $6 a month. We've got 5 ongoing lesson programs, each of them over 5 videos, some of them 20 videos, and I'm adding all the time. So check it out. There's also 2 free books there. My All Thumbs book on the dangers of cell phones and devices. First-rate research. I did real research on all this. And my autobiography, The Rhythm of History. So check it out. Also, help me turn Patriots history into a movie. This is our Sound of Freedom moment, folks. Help me make this into the next Sound of Freedom. And I'll see you guys back here on Monday.